I'm grateful to whoever has provided the file.
My lords, we were in the judgment. Sorry, we were in the claimant's the claimant's skeleton argument. The core bundle, tab 11, page 98. I was tracking through the claimant's skeleton, and we're still in ground 2. And if you go to paragraph 51 of the claimant's skeleton on page 98, very bottom, you see their criticism of using the citus of the causes of action. The judge's focus on citus should not have been allowed to drive the conclusion that English law governed the devolution of title to those rights. Instead, over the page, law of the deceased's domicile or the lex causae should have been recognised as laying down a more appropriate, and then this clear, coherent and stable connecting factor for the purposes of identifying the law applicable to devolution of title. And in my submission, that is a very doubtful claim. And we ask that the court consider the practical implications if the claimant's position were correct. We recall that we are concerned here with claims brought in England in respect of loss and damage suffered by a deceased who may have been domiciled outside of England. If the claimants are right, whether a grant of representation is required will depend on determining the law of the domicile or the law applicable to the underlying claim, or both. And both of those are fraught with uncertainty. On the claimant's approach, it would be necessary to determine if in fact the deceased did die domiciled outside of England, and if so, what was his domicile, which is often very far from clear. And the applicable law of the claim is often an entire separate dispute of its own. And in both scenarios, it would be necessary to discover what the law of the defendant's domicile or the applicable law of the claim said about title to sue. And all of this would have to be worked out by a claimant before issuing the claim. And the claimant runs the risk that after issuing the claim, he or she may turn out not to have had title to sue at all, depending on what the court ultimately determines was the country of domicile or the applicable law. This, we say, is a recipe, an obvious recipe for wasteful satellite litigation. And it wouldn't be confined, in my submission, to cases involving Brazilian law, because their arguments turn on the effect of the Cezine principle. And as we've discussed, in broad terms, many other civil law jurisdictions adopt a similar principle. And by contrast, we say the orthodox approach, reflected in My Lady's judgment, preserves a clear regime whereby title to sue in England is governed by English law, where it concerns loss and damage suffered by a deceased person. That means that any claim vested in the deceased person on their death may only be pursued by the duly authorised personal representative of the deceased person. And again, just stepping back and asking in reality, otherwise, what is the English court to do? And I have in mind the observation made by my Lord, Lord Justice Lewis, on day 2, when he said, if grant of representation isn't required in the claimant's case, and they can just turn up and say, I am an heir in Brazil, they could claim to be an heir held by, respective right of action formerly held by a deceased, and say, I'm the granddaughter, but don't worry, my aunts and uncles are all dead. And wouldn't the court want to know who is in fact entitled? Because anyone could claim to be an heir, because on this approach, you don't check whether or not they're entitled to be an heir in Brazil, and anyone could simply claim to be an heir in England. And my Lord, sorry, just to finish
Yes,
the point.
do.
That also applies to the sole heir scenario. Someone could turn up and say, I am a sole heir. But again, how are you to know? They might at that point even be in good faith a sole heir, but someone else could come out of the woodwork in Brazil and say, actually, I'm an heir as well. And the grant of representation process in England provides you, the court, with a clear starting point, which is title to sue, to pursue the action in the first place. I'm sorry, my Lord.
I haven't paid any attention to who the heirs are. That's obviously laid down in the Brazilian legislation. There's an order of priority, is there?
An order of priority for distribution in the sharing.
Or who counts as an heir? If you die leaving a mother, a brother, a child, a grandchild, are they all heirs, or which of them are heirs?
That is addressed. I'll be handed a cross-reference. There is
Yes.
an order of priority, and it has been specified in the Brazilian rules.
Yes.
Is that for intestacy? Because I got somewhere I read that you could have ordinary heirs as we would have them. You could just say, I like my gardener, my housekeeper, and I'm going to leave everything to them because I hate my family.
And again, different rules apply. And I'll get the cross-reference for you on that. But that's never been an issue.
No.
But the heir isn't just somebody, as you sometimes have in continental systems, that says it's got to be the sons, often not the daughter. There is the prospect of having free choice with your will, is there?
It's a mixture of both.
It's a mixture, okay.
But I'll be corrected.
Yeah.
There are yes. The testamentary freedom is more limited in Brazil, I think, than in England. But one is allowed to dispose of assets to others
Okay, yeah.
also. But the point's a really basic one, which is this approach, this time-honoured approach in England exists for a very good reason. It's not just a relic. It provides very important certainty to the court. And the consequence of the claimant's approach, far from being a solid, coherent and stable approach, which is what they claim, would be a recipe for uncertainty, satellite litigation and confusion here. And those consequences support overwhelmingly the conclusion of the judgment and all the authorities in my submission that we've taken you to. Finally, on ground 2, we have our respondents' notice. I'll just summarise it for you really briefly because it's a very short point. We draw the court's attention to Rule 30 sub 1 of the non-contentious probate rules. That's just for your reference in core bundle. Sorry, it's in the authorities bundle 1, tab 5, page 11. And it provides that if you are, in summary, beneficially entitled to the deceased person's estate under a foreign law, you may obtain grant of representation in England. And the short point is that would be otiose if the claimants were right in their application of the Sezine principle. You wouldn't need to rely on that. You would go straight to court. And we simply make the point that the fact that the legislature has created that power to grant letters of representation to persons in the position of these claimants strongly suggests that the law is as we contend and not as the claimants maintain. Moving on then to ground 3. Because by ground 3, as we've seen, the claimants challenge the judge's conclusion that even if title to sue were governed by Brazilian law, until the claimants are granted the right to sue under the formal de partia, they have not succeeded to those rights. They have not succeeded to those rights. And I was asked a question, I think, by my Lord Justice Nugee about the factual position in relation to formal de partia. And the point has been canvassed by the claimant's evidence. It's in a statement of Mr. Evans, the 12th witness statement, not in the bundle before you, the statement that was produced after the hearing below. We have copies for the court. May I hand them up, please?
Yes.
This is the 12th witness statement of Mr. Evans. It dealt with consequential matters following my lady's judgment. I'll just draw your attention to 2 paragraphs to address the question by my lord. If you go to page 15, please. Page 15, paragraph 48. Mr. Evans, for the claimants, I should say, we don't accept everything that's set out in this statement. This is the claimant's position on what is required in the formal de partia. For this limited point, we have no reason to disagree, but it's a matter within their knowledge. He makes the point of principle first in paragraph 48, 3 lines down. For ownership of deceased persons' causes of action against defendants to have validly passed to their heirs or donees in a formal de partia or deed of donation, those causes of action would need to have been independently and explicitly itemised in the relevant document. And the level of detail is then particularised. And over the page, paragraph 44, Mr. Evans says, my firm has not identified any instances in which the pre-issue deceased person's causes of action were specifically recorded in a formalde partia or deed of donation. So, coming back to ground 3, the key point here in the judge's finding is that to have succeeded to the claim, the claimant would need to have the right to bring it for the benefit of his own personal estate solely and exclusively, and not for the benefit of the deceased's estate and all those persons interested in the estate, such as other heirs. If the claim is for the benefit of his own personal estate only, any recovery under the claim will form part of his own personal estate only. And even applying Brazilian law, that is not what these claimants have. They are suing in their own names, but for the benefit of the indivisible inheritance as a whole. And any recovery from the claims is for the indivisible inheritance as a whole. The heir who succeeds in obtaining the recovery, as I said earlier, cannot touch a penny of it until the estate's liabilities are discharged and the distribution takes place. The claimants challenge the judge's findings. That is, in my respectful submission, already a difficult task. I'll take the court to the authorities in a moment on how one can challenge foreign law findings at first instance. But the claimant's task is made even more difficult by the fact that the judge relied for her findings on the claimant's expert, not on my expert. She didn't like my expert at all. She much preferred my learned friend's expert and relied heavily on his evidence to make the findings which my learned friend now challenges. And I shall take you to the references to Professor Schenk in the judgment and in the claimant's own skeleton. But that's the legal standard when challenging findings of foreign law. I'd ask you to turn up Banca Intesa, volume 4 of the authorities bundle, tab 55. Tab 55, page 1484, please. 1484. Paragraph 61 is a question of Italian law. Submissions were made that the judge wrongly concluded that the transactions infringed Italian law because he misanalyzed the transactions and wrongly concluded that rolling them over made them speculative. That tells you that the expert in this case was engaged not only in determining what Italian law was, but also how it was applied. And that's an important distinction. Where the only question for the judge is, what is the foreign law? The Court of Appeal is normally even more reluctant to interfere with the judge's finding. Here in Banca Intesa, the judge was doing both. In paragraph 62, counsel took the court through the Italian Supreme Court decision Cattolica, which that was analysing what was the Italian law. In paragraph 65, counsel accepted that the appellant needs to win on both grounds. And she dealt with the standard of review in relation to findings of foreign law and referred to Privy Council in Perry and Lopez Trust. And for this, my lords, I'd ask you to turn over the page to page 1485. The very last paragraph, skipping down to the second line. The court went on to state it was not entitled to substitute its own view for the view of the trial judge when there was acceptable evidence to support the judge's findings, unless the English court interprets the statute in accordance with English rules of construction. And there's no evidence that different rules would govern the foreign court's construction or evidence. top of page 1486. The court observed that where the court was faced with differing views as to Italian law, which was not based on any relevant aspect of the common law, there was less room for the judge to apply his or her legal training and experience to help to resolve the relevant question. And we make the point that Brazilian law is in the same position. Thirdly, where foreign law is in a foreign language, as it was here, the trial judge will often be dependent on translations, which may or not be precise, which may or not be disputed, on the evidence of the foreign law experts to understand the meaning and nuances of the foreign language in the relevant case. And relying on Byers and Saudi National Bank and the Court of Appeal, skipping down 4 lines, the Court of Appeal concluded it should be slow to interfere with the judge's findings of fact on Saudi Arabian law. It should do so only in accordance with the principles generally applicable to findings of fact made by a trial judge who has based his findings on evidence from witnesses. Skipping down to indented paragraph 14, further and more widely, where the first instance judge is dependent upon the evidence of foreign law experts who disagree, as they did here, as to the interpretation of the application of foreign law, and has to decide issue by issue whose evidence to prefer, the judge will have regard to all the evidence presented to him or her. The judge will reach a view based on an assessment of each expert, having regard to each expert's evidence as a whole and the way in which each expert answered the questions posed in chief and on cross-examination to justify his or her opinions. The judge will evaluate the expert's reasoning, and not all the matters which have influenced the judge in forming a view of which evidence to prefer will always be recorded in any detail in a judgment or can be ascertained from reading a transcript. He or she will have regard to the whole of the sea of evidence presented to him or her, whereas an appellate court will only be island hopping. 15 is thus a spectrum of circumstances in which the principal variable is the degree to which the judge can use his or her skill and experience. One of us can read the rest of paragraph 15. It's the first third and the second and the last third that matter. I only need you to read the indented passages before paragraph 66. And then please go to 1510, page 1510. Paragraph 151. An important initial question is where on the spectrum identified by Lord Hodge and Perry the present case sits. To the extent the judge made findings as to what Italian law was, for example, what the Italian Supreme Court in Cattolica decided, he was dependent upon the evidence of the experts about a civil law system with concepts unfamiliar to English lawyers, with a variety of sources of law. It's well established that in relation to those findings of Italian law, the approach is the same as you'd approach to findings of fact. The court will not interfere with those findings unless they were plainly wrong. But to the extent there's an application of those legal findings of the facts, less deference is shown. We are concerned here, my lords, with the judge's findings as to what Brazilian law is. There was no application of that law to the facts by the experts. And she was plainly dependent on the evidence from the experts. It was tested in cross-examination, and it was certainly not familiar to an English judge. And so for the same reasons we say the court should be slow to intervene. But looking at the judgment now itself, and the basis on which my lady made her findings on Brazilian law, I could ask you to go back please to the core bundle, tab 15. On this ground, I propose to take the court quite carefully through the judgment and through the claimant's skeleton. I won't be going through reams of Brazilian law. I submit that you'll get what you need from the judgment and from the claimant's own submissions. It's page 256, please, of the judgment. Paragraph 229. So here we have position summarized by Professor Schenk, my own friend's expert in the joint expert report, paragraph 3.1. The rights are transferred to the heirs at time of death, according with Zazine. Since they're the owners of the assets that make up the estate, they have concurrent standing to issue a claim on their own behalf, but then this, in defence of the common patrimony. And after distribution, when the indivisibility in respect to the shared property and rights ends, so it's indivisible until the sharing, the standing belongs, after sharing, sorry, the standing belongs only to the heir to whom the property or right has been attributed. And the point I'm making throughout all of this is the nature of the claims, however they're labelled in Brazilian law, are representative. And we get that from the next paragraph, paragraph 230, quoting from paragraph 2.5 of Professor Schenck's evidence in the joint expert report. He says the heirs are the owners of the assets and rights, the ownership of assets and rights, and then this, and the status of indivisibility of the inheritance until its distribution guarantee the heirs concurrent standing to bring a claim in their own name, and then this, in defence of the common heritage, and I paraphrase, and only in defence of the common heritage. In cross-examination, Professor Schenck's evidence, next paragraph, relied on an article of the Brazilian Civil Code, and this allows clearly, said Professor Schenck, especially when seen according to the constitutional principle of access to justice, that the heir can exercise the defence of his own interests, and then this compatible with the indivisibility principle. We've seen in the cases, said Professor Schenck, that the defence of their share is in their own name, and as a consequence, it involves the defence of the whole inheritance. Professor Schenck went on, the estate, so recognising that the estate is a concept in Brazilian law, paragraph 232, is the name given to the inheritance in Brazilian procedural law. The estate is a group of assets authorised by procedural law to sue and be sued until the distribution of the inheritance to the heirs.
Can you just pause one moment, Mr. Kennelly?
Sorry.
I've been given a note to the effect that the recording has stopped. I'm not sure whether that affects the shorthand writers. It does affect it. That seems quite a problem. Do you know what the problem is, the source of the problem?
I don't know. It may take at least 5 or even possibly 10 minutes to fix, I'm afraid.
Mr. Kennelly, how are you doing for time?
I'm just about keeping to my plan. I mean, I can only work with what I have. So if we need to stop for 5 or 10 minutes, then I'll have to cut back.
And the recording's still going, so we could perhaps insert that missing bit afterwards.
Would you mind doing that?
Okay.
Thank you very much.
But in general, we have to finish, and my friend has the right to reply.
Yeah,
so
absolutely.
I
Yes.
have that well in mind.
And the shorthand writers are very helpfully allowing us to proceed on this basis.
Indeed, and I apologise for the speed with which I'm rattling through my submissions. The judgment goes on to emphasise again, in this same, just quoting really from Professor Schenck is saying, that again, the heir is acting in defence of the assets and rights that compose the inheritance as a whole. And 233, Professor Schenck accepted, and there's no suggestion that the judge misinterpreted Professor Schenck's evidence. He is defending the assets and rights that compose the whole of the inheritance, not just for his benefit, but for the benefit of the other co-owners of those assets. And he was referred, paragraph 234, to paragraph 40 of his report, in which he said that the proceeds of any claim will not automatically be part of the property of the heir. Pausing there, that is obviously right if the inheritance is to be indivisible until distribution, but will be subject to the sharing and distribution amongst the heirs. Said Professor Schenck, skipping down 3 lines, the proceeds awarded to the heir in the legal claim will not be considered automatically as personal patrimony of that heir. The Brazilian succession law mandates that the asset or right granted in court be subjected to the inventario proceeding, that is the administration. This means the award would need to be shared amongst the other heirs through individualization of each heir's shares by a distribution or new distribution. The legal requirement aims at protecting the interests of the heirs who chose not to file a claim in defence of the common patrimony. Again, this is all of a piece. It is all indicating that the claim brought by the heir in his own name is in truth representative. 235, Professor Schenk's evidence in cross-examination was that the heir was nevertheless exercising his own rights and not representing the interests of the estate. He said the concurrent standing does not mean the heir is necessarily representing the interests of the inheritors in court. He cited in that italicized passage, paragraph 40 of his opinion, because the heir is defending his own share of the inheritance, defending the inheritance as a whole, such benefit might be attained and will be shared amongst other co-heirs. And when it was put to him that he wasn't just defending his own interests, the heir, but defending the interests of all of the inheritance, Professor Schenk's response was that the heir is defending the interests of the whole because, now on page 258, it's not possible to individualize one's share. And this is very important because my friend rather glided over this. The heir defends the whole as a reflex of defending one's own share of the inheritance as the law states. The ideal inheritance share, there is an ideal share, the heir is the owner of an ideal share of the inheritance. Now, that again, in my submission, appears to be a translation, and in my submission, what the expert meant and what the judge certainly treated him as meaning was some kind of theoretical share. The heir cannot have a concrete individualized share until the distribution. So at most what he has until the distribution is a theoretical share or an ideal share which he's seeking to vindicate. But what is absolutely clear is that the whole of the inheritance benefits from any victory. He may get nothing, but if he gets something, but if the claim is successful, it goes into the inheritance.
Would undivided share be a suitable translation of ideal?
I have asked what is the best, what ideal might mean here, and I'm waiting for a note. Undivided.
Because we are very familiar with the concept of joint owners owning the whole, but not owning any individual shares, but owning the whole in undivided shares.
In my respectful submission, my lord, I'm not sure undivided is the first place I'd go in thinking about what ideal means here, because the expert is struggling to describe what the heir, to the extent the heir is looking after his own interests, what is he seeking to vindicate here? And the ideal share, the ideal inheritance, that he's, perhaps it makes no difference whether it means undivided or theoretical.
It reads to a non-Portuguese, non-English speaker as, in a perfect world, the thing he'll finally get.
That could also be true, but the key point is that the heir here is not necessarily going to get anything at the end of the sharing, even if he wins in this case. But what is crystal clear in common ground is that to the extent he wins anything, it goes into the common pot, the indivisible inheritance. Well, what he gets after sharing is a whole different story. He may get nothing for his efforts.
That's an interesting question. Say he wins £1 million. Who does the defendant write the cheque to satisfy the debt?
I think that because the estate doesn't have legal ownership, the estate itself cannot be written the cheque.
There's really to the estate or even to the representative of the estate, really.
I'll have to check that because if the estate has an administrator, if there's an inventariante administering the estate,
You get it.
he'll get it. He should get it. I'll be corrected if I'm wrong about that. Yes, I'm told if a cheque is written for the benefit of the indivisible inheritance, it should go to the administrator of the estate, the inventariante, who administers the estate. And the administrator has particular duties, particular to the administrator, and it's common ground that the heir is not the administrator. The heir is.
But if there
Not-
isn't an inventariator, who gets the cheque then?
If there's no inventariante, if there's no administrator,
Yes.
presumably the heir will get the cheque. But he cannot treat that cheque as his own property. He must handle it for the purposes of the inheritance as a whole. Ordinarily in Brazilian law, and again I'll be corrected, there will be an administrator. Somebody has to pay the debts of the estate and pay
With the debt, the funeral expenses, the
Indeed.
taxes.
Yeah. So whoever is doing that will ultimately receive this money. And even if the heir holds the cheque, even if the cheque is made out to the heir, and I'll be told if the cheque goes to the heir or not, it doesn't matter. The point is, it is not his.
To dispose of as he wants to.
Absolutely not. It cannot be disposed of until the sharing has taken place. I'm sorry. Sorry, this is a separate point is made to me as to why this is a further reason why there should be someone with a grant, so there is good receipt. It's again a practical point. If on the claimant's approach there wouldn't be any grant of representation, you'd have to work out who gets the check, even though it's going indivisible whole and not on common ground, not for the disposal of the heir by himself. With a grant of representation, the English court knows to whom the check should be written. Staying on page 258 and paragraph 238 now. Although Professor Schenck was of the view the heir was bringing a personal and not a representative claim, he accepted that the heir was defending the inheritance as a whole. And the judge said even if it is a personal claim in some sense, the heir is not absolutely entitled to the claim even as a matter of Brazilian law. The Brazilian succession law, as Professor Schenck said, mandates that the asset or right be subject to the inventario proceeding. And that, I think, answers my Lord's question. This means the award would need to be shared among the other heirs through individualization of each heir's shares via distribution or new distribution. And he was taken to a judgment of the Brazilian courts, where the issue was whether the lawful heiress of the co-owner had legal standing to sue in her own name to defend the deceased's interests before the distribution. And in holding that she had standing to sue, the judge said, standing to sue of the heir is limited to the defence of the interest of the estate itself, not including the defence of individual interests. The standing to sue as a result of the right of saisine and the indivisibility of the inheritance may be extended to the co-heirs before the distribution is carried out, so they may sue. However, this exceptional extension of legal standing is limited only to protect the interests of the estate. And well, as we go to the page to 243, we see the judge's conclusions, paragraph 243 and 244, which again emphasize the points that I've been making throughout. So what do the claimants say to that? And if we go to the claimant's skeleton, at tab 11, we see in my submission that the claimant's arguments are unsustainable on their own face, on the face of their own skeleton argument. If you go to page 100, please, in paragraph 57. The claimants summarise the position, and 3 lines from the bottom, they say that they don't take issue with the judge's primary findings of fact in relation to Brazilian law. But they say that she urged applying the wrong test or evaluating the evidence in a manner that was so flawed as to be wrong. Paragraph 102, please. So page 102, paragraph 62. Point 2. They summarise what Professor Schenck said and what the judge upheld. And at the bottom of 62.3, the claimants make the point that it's the inventariante who has procedural capacity to represent the estate, whereas heirs sue in their own name as owners of the cause of action. Supposing there, even if, as the claimants say here, the inventariante has to manage the estate, pay off the debts, and be responsible ultimately for the sharing, that does not mean that the heirs should be treated as if the claims have been distributed to them to their own personal exclusive right and in their own estate. 62.5, the claimants acknowledge that estate is defined by Professor Schenck and is a creature of Brazilian law. And if you go please to paragraph 63, the claimants cite Article 1314 of the Brazilian Constitution, about 3 lines down. as the joint owner, the heir can exercise all rights, but then this, compatible with the indivisibility. We saw that earlier. So he acts in the interest of the estate as a whole, even if he hopes, with no guarantee, to get some share at a later stage. And that lack of any specific personal share in the claim, which is being pursued, is the fundamental flaw at the heart of this ground of the claimant's appeal. It prevents any finding that they have some absolute entitlement to the claim and the proceeds of the claim, like Madame Vonquelin had in her case. Then, even the claimant skeleton acknowledges, pursuant to the Brazilian rules, that halfway down the paragraph, thus the personal right that an heir has prior to the issue of the FDP to advance a claim that comprises part of the inheritance which vested in him as a result of the Zazine principle is inviolate as a constitutional entitlement. But no specific part of the inheritance has vested in him. That's not Professor Schenk's evidence. You've seen what Professor Schenk said passes in the Zazine principle. The heir, if he sues, does so for the good of the whole, for the good of the indivisible inheritance. In paragraph 64, here the claimants are challenging the judge's finding that where the heir is defending the estate as a whole, he is in substance doing so on behalf of the estate. But that, my lord, is exactly what is happening. Prior to the FDP, there is no individualized interest. There is nothing for his personal estate. Not even, as I said, a guarantee that he will get anything at the end of it. And that is, so what he does bring is obviously a claim brought on behalf of the estate, however the claimants label it. And you see in the claimant's own skeleton, they highlight in bold the passages that I've taken you to in the judgment, just above paragraph 67. Paragraph 68. Here the claimants try to make something of the fact that an heir can sue for the benefit of the estate, even if other heirs object. So that that was put forward as a reason why it should be treated as if the heir has some specific individualized interest. But that is irrelevant in my submission. It's a central finding in the judgment that even in that situation, even if other heirs object to the heir bringing the claim is still for the benefit of the estate as a whole, and not for the personal estate of the claimant. Page 107, please. Here, the claimants finally confront the fact that an heir bringing a claim for the good of the whole estate does so with no vested right in any specific asset and may receive nothing in the sharing. They say the judge's conclusion that heirs do not have the requisite absolute entitlement to enforce their claims personally prior to the FTP, and that this means it's part of the administration, is unsustainable insofar as it's based on the second factor she identified, that the proceeds of any personal claim brought by an heir prior to the sharing do not automatically form part of the personal estate that are subject to the distribution process. And they repeat the judge's reasoning that even if it's a personal claim, the heir isn't absolutely entitled to it. It has to be put into the common pot and shared. 72, Professor Schenk also explained that there's a distinction between an individual's personal entitlement to advance a jointly owned cause of action and their lack of entitlement to immediately and personally possess the totality of the proceeds of any such claim, instead of being obliged to account to the co-owners. But the judge did not, then they ought to say the judge conflated these two concepts, but she did not do so. She recognized, as you've seen in the judgment and the passages I took you to, that an heir could bring a claim even before the sharing stage, but she found, on Professor Schenk's evidence, that such a claim is for the benefit of the estate as a whole only. And the question of standing to bring the claim does not guarantee the claimant, the heir claimant, will get anything in the sharing. And the claimants acknowledge that the heir may not, well, the claimants say, sorry, that the heir may not get immediately and personally possession of the totality of the proceeds. That's not quite right. Professor Schenk acknowledged, far from not immediately getting the whole thing, the heir may get nothing. There's no link between the right to bring the claim for the good of the inheritance as a whole and the right to claim something specific for the heir's personal and exclusive estate. Then page 108, please, still in the claimant skeleton, there's a point about sole heirs. I've already explained why that argument is wrong. Also by reference to the judge's finding in the consequentials judgment. Just for completeness.
Just before you leave that, have we got a reference to the effect that where you have a sole heir, you still need the FDP?
The only reference I have, my lord, is the one I gave you in the consequentials judgment.
Yes, I see.
The issue wasn't, the point wasn't taken until that stage.
Yes,
And the judge said, based on the evidence that she'd seen, since no distinction was made,
I follow. So it isn't the case that we can find in Professor Schenk or somewhere something saying that.
not to my knowledge. Again, I'll be told if I've missed something, but that's
Yes.
my understanding. Because the judge had a great deal of expert evidence on what Brazilian law required, where sharing was required, the process, how it worked comprehensively. And since there's no evidence to the contrary to suggest that the sole heir would somehow be excluded, and logically, why would they?
Yes.
She was entitled to conclude that they would be treated in the same way. May I show you, just for completeness, the Professor Schenk's recognition that Brazilian law recognises a period of administration in the supplemental bundle. You see it in the transcript, tab 40, please. And it's page 118 behind tab 40 of the supplemental bundle note.
Yes,
That worryingly slim volume in your hand.
that's got tab 4. Well, they've been subdivided, I think, by the
The
table.
third volume of the supplemental volume.
Tab 40, page 660.
Ah, okay, I had 118.
Oh, I'm so sorry. My mistake. Page 118 of the transcript. I'm very
Oh,
sorry.
right, I beg your pardon.
Page 660 of the bundle. Page 118.
Oh, I see, there's more numbers here.
And I'm asking the question at line 6. You accept there's a period between the death of the deceased person and the distribution of his or her assets to those entitled to those assets. And Professor Schenk answers yes. And then skipping down, I ask about how are creditors paid from the assets of the estate when they're owed sums. And Professor Schenk says at line 20, the inventario, in the inventario, the assets of the inheritance and all liabilities of the inheritance are also listed before sharing to the heirs. And then at page, 119, he describes at line 10, when there's a collection or the surmising of all assets of the inventario process, we verify what are the assets, what is the patrimony, what are the rights, what are material and immaterial assets received by the heirs. And also you tally up if the deceased has left debts, and then there will be decided those debts are part of the estate of the inheritance. The assets of the deceased that are part of the inheritance will be used to liquidate those debts, and the heirs will receive the remainder of what has been paid for. And I asked Professor Schenk, do you agree that this process you just described is part of the administration of the estate? And Professor Schenk said, yes, I do. And if you go please next to page page 661 over the page. page 121 of the transcript. I asked, by reference to his report, the filing of the inventario and distribution is incumbent upon whoever is in possession and administration of the estate within the deadline. And I asked, this part of the law identifies a period of administration of the deceased's assets after his death, but before those assets are shared. And Professor Jane said, yes, this period points the administration of the assets of the deceased since the moment of the death up to the moment of sharing, which involves the opening of the inventario. And the references to Brazilian legislation are made by Professor Schenk, just for your note. It's in the Authorities Bundle, tab 9, pages 264 to 265. It's Article 613 to 617 of the Brazilian Code of Civil Procedure. My lords, Professor Schenk very fairly and accurately set out the position of the Brazilian law. It was preferred and adopted by my lady, and it was that which led her to make the findings she made as to how these issues would be characterized, even if one looked from the perspective of Brazilian law. And those are my submissions on ground 3. I'll move on, if I may, to grounds 4 and 5. Just to recall the background, the effect of the finding that certain claimants needed and lacked a grant of representation was that they were a nullity when they were issued or added. And at the risk of repeating myself, you have my submission that a claim which is a nullity must be struck out for the reason that there is no valid claim. The claimants sought to avoid that outcome by inviting the court to exercise a discretion not to strike out the representative and heirs claims in reliance on Rule 17.44. But the claimants hadn't actually made an application under Rule 17.44. Instead, they indicated they might potentially rely on that provision in the future, in that the relevant claimants might obtain an English grant in the future, and they might then make an application under Rule 17.44. For your lordship's notes, only 3 claimants have actually obtained grants of representation. The judge assumed, without deciding, that she had a discretion not to strike out the relevant claims. But she refused to exercise any discretion not to strike out those claims for which a grant of representation was required. And grounds 4 and 5 are a challenge to that exercise of discretion by the judge. And because they're challenging an exercise of discretion, the claimants need to show that the judge's conclusion was clearly wrong, that she exceeded the ambit within which reasonable disagreement is possible. And in our submission, grounds 4 and 5 do not come close to discharging that heavy burden. The exercise of her discretion was, in our submission, unimpeachable. The defendants raised here also a respondents' notice, which places before the court a point that the judge didn't have a discretion to exercise in the first place. We say that the jurisdiction under Rule 17.44 can only arise if there was an extant application to amend at the time of the order. There has to be an actual application without which the judge can't say. The judge couldn't exercise a discretion in favour of an application under Rule 17.44. And here, apart from the 3 grants of representation I've mentioned, the claimants haven't put themselves in a position, not even in a position where they could apply under Rule 17.44. They haven't obtained the grants of representation that they would need to make such an application. And even now, that remains the case. The judge was asked to assume that grants of representation would be obtained, that applications under Rule 17.44 would be made and they would be successful. We say that the judge was not in a position to make those assumptions. The claimants say, applying Kim and Park, that because this is a strikeout, our complaints are really about pleading defects, which should be assumed will be fixed. But in our submission, this is not like a pleading defect. This is much more fundamental. And I'll show you Kim and Park first. The claimants rely on it. It's in the second volume, Authorities, behind tab 25. Paragraph 1, what's that, page 736, please. Paragraph 1, the claimants appealed against an order where he struck out the claim, and the reason, paragraph 1, he gave for striking out the action was the claimant had not identified any person who had accessed the websites on which the words complained had been published. It was a libel claim, and they failed to plead that anyone had actually accessed the websites on which the words complained of had been published, which was a necessary component for a stateable case in libel where the publication was online. Page 739, please. Paragraph 26. That just tells you that you do need to plead that someone has accessed the website where you're complaining about libel published in that forum. And then page 741, paragraph 38 under the heading Discussion. Ms. Justice Tugatat said, in my judgment, the Master took an unduly restrictive view in saying that the claimant, that the information which the claimant provided after the judgment was circulated in draft was too late to have any effect on his decision to strike out the pleadings. The claimant produced a witness statement saying he could find someone who had accessed the websites. And the Master said it was too late. 39, he was entitled to hold that on the material that had been before him at the hearing, the claimant could not succeed at trial simply on the basis that publication to readers of the articles on the website could be proved only by inference. It would follow from that list the claimant could succeed only by calling evidence of publication to identified readers. However, when the court holds that there is a defect in a pleading, it is normal for the court to refrain from striking out that pleading unless the court has given the party concerned an opportunity of putting right the defect, provided that there is a reason to believe he will be in a position to put the defect right. And the Master here recorded the claimant had informed him he had already had witnesses. It wasn't wishful thinking or bluff. He had statements which he did submit. So it was wrong in principle for the Master to strike out the claim. The present case, in other words, is very different. The relevant claims are a nullity because they were issued by persons acting as representatives but with no grants of representation. As I submitted earlier today, that is not a procedural defect. It's not one, it goes to substance, and it's not a defect which the court can assume can be cured based on the assurances from the claimants. Here, the claimants provide no such assurances, or at least no assurances upon which this court can rely, because the court will recall a condition precedent for an order under Rule 17.44 is that the limitation period has expired. The claimant's case is that no limitation period has expired. Their case has to be that an application under Rule 17.44 is impossible. Now, we raise a separate issue in our respondent notice as to whether 17.44 can ever be used to cure a nullity, even after the limitation period has expired. This the House submission is an open question, but it doesn't really arise here because no application has been made under Rule 17.44. And on the claimant's case, they do not satisfy the requirements of the provision at all. On the earlier point about whether 17.44 could even be relied on in principle, we recognise the point made by our friend that we rely on Justice Reimer's obiter comments in Milburn-Snell to disagree with the obiter comments of the Privy Council in Jogi. I recognise this court may well prefer the views, albeit obiter, of the justices in the Privy Council. I will not say any more about that point now. It's an important point of principle, and we wanted to keep it open, but I won't focus my oral submissions on that point further.
We're not bound by any decision of this court, are we?
No, that's why it's
It's an open question.
That's why it's an open question, my lord.
I thought Lord Newberger told us in Willers and Joyce that generally we ought to follow the Privy Council unless there was authority binding us to do otherwise.
That is precisely what he said, my lord, and that's why I will not detain you further on it. But I'm not conceding the point.
Yes,
It's an interesting point, and I wanted to keep it open.
You want to keep it open.
I want to keep it open, but I have better points to make. And the first is that there's no application under there was no application under Rule 17.44 before the judge, and there could not have been, because it involves an acknowledgement that limitation has expired, and the claimant's case is that limitation has not expired.
I thought the claimant's case was that limitation has now expired, or at any rate.
The claimants rely on what they say. That was the suggestion in oral argument,
Yes.
and they say that comes from paragraph 27 of their reply. Should we look at paragraph 27 of their reply to see their acknowledgement that limitation has expired, so as to allow them to make an application under Rule 17.44. That is in the core bundle behind tab 27, page 476. So paragraph 27, they say it's denied that the claimant's claims against defendants are time barred. The limitation period did not start to run until at the earliest, the date of publication on the 6th of March 2018. Which is the earliest possible date in which the claimants obtained the unequivocal knowledge. The facts relevant to their right of action were deliberately concealed. Moreover, the limitation period was restarted by the filing of protests on behalf of the claimants before the Brazilian courts between November 2019 and March 2021, and the effect of these protests was to restart the 3-year limitation period, the date of the last procedural act. So in the face of their pleading, a limitation has not expired. That is not an acknowledgement that limitation has expired in any sense.
I see the point in terms of the words, but the proceedings were issued in 2019. The second set of amendments was made in January 2020. They must have had knowledge by then, mustn't they?
Well, our case, of course, is that they had knowledge.
No, I follow,
Of course.
but if it's 3 years from knowledge, it's hard to see how it can be later than 3 years from January 2020, or I suppose conceivably 3 years from the 5th of March 2021. But both those have passed.
Yes, but not, I'm sorry, my lord, but passed now,
Yes, I see. So you say not passed by the time of the judge's decision.
and not passed by the time of the claims, the claims in question.
How would it work? So suppose that contrary to the judge's decision, we said, no, we're not striking out now because the claimants should have a chance to get letters for a grant from the appropriate jurisdiction here.
Yes.
So they then get the grant. What happens then?
With a grant, they could make an application under Rule 17.44, but they would have to accept that limitation had expired in order to rely on that provision.
Expired at which point?
Expired at the time of the application. And the difficulty, I'm so sorry, Margaret, let me just quickly check something. Sorry, just to complete the picture on paragraph 27, you will see at the very bottom of paragraph 27, just to ground ourselves in the pleading, they also plead that to the extent it's ultimately shown the cartel operated before or after the admitted cartel period, the limitation period has not yet started to run. And that, of course, is now their draft pleaded case. That is their new pleaded case that I showed you.
Yes.
The question, though, before the judge was, when those amendments were sought to be made, at that point, could she give them the benefit of the doubt that they would make a Rule 17.44, or could she give them the benefit of the doubt that that was an application they could have made? And the answer is no. There was no application before her. They didn't accept that limitation had expired, and this pleading does not come close to showing an acceptance that limitation has expired. On the contrary, it pleads positively that the earliest date for unequivocal knowledge was March 2018. One adds 3 years to that. And then, even then, the protestos restart the limitation periods from 2019 and March 2021. And then the final point, in any event, the cartel period continued far longer, and there's no question of limitation. So they had, it was said rather quickly, well, of course, we accept the limitation has expired, but this was not the case in the reply.
Turning back from it, you were applying to strike them out, and the reason why you're trying to strike them out on this basis is that the wrong people have brought the claim. And they say, well, if you're right, we're sorry about that, we'll go off 3 of the test cases, we've got it, we'll get it to the rest of us. Either they're within the limitation period, in which case, why is a matter of discretion ought there to be an adjournment or a refusal of the strikeout? Or they're outside the limitation period, in which case they could have got it and applied to amend. It seems slightly technical. You should win, but you didn't win at the right time or in the right way, so now we're going to take away your cricket bat. That doesn't seem desirable, does it?
Well, as the judge found, again relying on what the court said in Jogi, is these rules are not, they may seem, perhaps the way I'm presenting them is not very technical, but they give certainty.
I understand you need a procedural framework within which claims are brought. But if you're saying we want to strike out because there's no grant of administration,
yes,
you have these Brazilian granted knowledge grown, you say very well, we've made a mistake, we get it.
I think there's no reason for the indulgence, my lord. This claim is brought by a very well organised, well-funded, and well-represented team, and they had a long time to get the necessary grants and to have organised themselves. And even now,
the team doesn't lose. It's the orange grower in Brazil, or more correctly, the heir of the orange grower in Brazil.
my lord, these proceedings, the proceedings have been on foot, as you've seen, for some time. Even now, we see how much work has been done to get grants of representation. It's really surprising so little has been done to get them. 3 grants of representation, even now. The claimants have put all their eggs in this basket, the big play, and they have not protected themselves. And that is their own choice. And if that's a mistake, that's a matter for them. There's no call for indulgence here.
Did you say the rules are clear if they haven't complied with them? So well, that's it.
That's quite right, my lord. And to the extent that it's said that you can get around the nullity, that's an even more serious problem, because these are
Well, that's different.
matters of substance, not of procedure. But it's a fortiori when we're asking about the judge's discretion. And that's what we are talking about in this context. And we'll see how she exercised it. It's in core bundle, tab 16. This is the consequential judgment. Page 271. Paragraph 38. Page 271. The point I've just made to my lord. And what's curious here is that the claimant said, as the judge recorded, they were in the process of obtaining the grants in correspondence, they said, from March 2022.
Sorry, where do I see that?
The bottom of page 271.
Yeah. I
And
see it.
this is the point about the claimant saying, well, we could get the grants, we could make the applications, and the judge accepted based on what she saw in the correspondence, is that the claimants should obtain the English grants. They said they were in the process of applying for them in March 2022.
Some of the claimants, I don't know if that's the test claimants or not.
Well, the claimants, this is the very issue we're talking about. These are the claimants.
No, I understand that. It's just you omitted the words for some of the claimants, and you said they were in the process of obtaining them in March 2022.
Yes.
And all I'm saying is it says for some of the claimants, and I don't know what those words
Oh, I'm so sorry.
meant to refer to, because I've seen reference to 3 test claimants, and I just don't know what that's a reference to.
Indeed, my point is a different one, which is that they were on notice of the need to get grants, and they said they were doing it more than 2 years ago. And of course, it should have been done even sooner, considering the claim was issued in 2019. So, page 274, please, paragraph 49. Again, in the exercise of the judge's discretion, she says, as to whether limitation may expire in the future, thereby precluding the bringing of new claim, it is, in my view, partly, if not largely, of the claimant's making, in that it appears at various stages through the proceedings, the claimants took the view that grants would be required, but subsequently decided, possibly for reasons of time and cost, not to seek grants except in limited instances. Besides Mr. Evans' fourth witness statement. In paragraph 50, irrespective of whether there was a good reason for the claimants not to pursue the obtaining of grants of representation, in the circumstances of this case, I do not accept that strikeout would undermine the policy and intended effect of the legislative scheme. The defendant's case, that limitation expired in 2009. The claimants have not pleaded a positive case. The limitation has expired, relying in this context solely on what they termed an unresolved limitation dispute. And assuming, in the light of the Ober comments in Jogi, that the court has a discretion as to whether or not strikeout should be ordered, where the limitation period has arguably expired, in my view, this is a case where the claimants are seeking to take advantage of a provision which they have not yet invoked. There is no application under Rule 17.44, and no grants have been obtained which would enable them to make such an application. To the extent, therefore, that the court has a discretion, I decline to exercise that discretion. In my view, no application has been made, and the general law should apply. The claim should be treated as a nullity.
Just picking at one point, in 49, we see Mr. Evans quoted as saying, in March 2022, the claims of any claimants who died before the claim form was issued or whose estates may not have obtained the requisite grants of representation in England would be regularised as soon as possible. Does that on the face refer to all the relevant claimants?
My lord, yes, because he says, in fact, I should have read that as well, because Mr. Evans there is saying, he said to the court more than 2 years ago, with the benefit of specialist probate lawyers in English, he says the outcome of this work is that claims of any claimants who died before the claim form was issued or whose estates may not have obtained the requisite grants of representation in England will be regularised as soon as possible. A clearer statement is hard to imagine. And as I said, there's nothing to suggest that the claimants with their lawyers and specialist probate lawyers could not have done so. To the point that was put to my friend in argument by Lord Justice Nugee, we also do not accept that the process of obtaining grants is extremely expensive and cumbersome. It may take time where large numbers of people are involved, but the process itself, there's no evidence before you, so the limit to how far I can push this, but we don't accept that there's anything particularly onerous or difficult about the process. It may take time because of the numbers involved.
Can I just pursue it a moment longer? We've got somewhere, haven't we, the grants that have been obtained?
The English grants I've not seen. I've not seen the English. I've seen some Brazilian documents, but the English grants representation I do not think I've seen.
I thought I had seen them somewhere.
That's not bad, by which I mean they're not in the bundle.
And if they're not in the bundle, then I must be mistaken in thinking I've seen them somewhere.
I canvassed the bundle pretty thoroughly, but it's possible I missed them.
What do we have at supplemental F, tab 38, page 635 onwards?
I beg your pardon, my lord,
Tab 38, page 635 onwards.
That looks like, that does look like a letter, well, it's called a letter of administration. These may be the three sample, these are the three sample grants which were obtained.
Yes, I see.
So, my lord, you're quite right.
But plainly, they don't of themselves reveal when the applications were made or anything of that kind.
I can't see an application date on the face of the document.
No.
So no doubt my own friends will be able to assist you there.
Yes.
They don't seem to attribute a very large value to the claims.
Then can't.
Point I can hopefully will never need to come to. So, the question for my lords is whether the judge's exercise of discretion was clearly wrong, whether she exceeded the generous ambit, and in my submission, they don't come close to that. On the contrary, their position, the claimant's position, is quite unreal. They say that the judge exceeded the generous ambit within which reasonable disagreement is possible because she failed to assume in their favour that they would be able to get the grants representation and they would make the applications under Rule 17.44 and they would succeed, despite all the obstacles in their own case, which indicated that was highly unlikely. And so sorry, lords. Many of these points I've already made. The next point I was going to make was that my submission is consistent with the policy behind Rule 17.44, but I think, when I say so, that was a point that we discussed already, and it was drawn out by Lord Burroughs in Jogi at 46, and the need for certainty and clarity in ensuring that claimants are properly represented according to the rules. And my final point is that this, to the extent that there is a problem, it is one of the claimant's own making and not one that deserves the indulgence of the court, even if you were in a position to do so. And it is a real stretch to say you can when there's no application before you and they don't accept that invitation has expired. The idea that a 17.44 application will be made is quite unreal. Unless I can assist you with anything else on those are my submissions in response to the claimant's grants of appeal. And now I have some short submissions to make on my final grant. The way we organise our time is that I will now make my submissions on my last grant of appeal, grant 3. My friend will respond in reply on his appeal, and then I'll have a short, very short reply to my ground 3. Our ground 3 is linked very closely to the points that have now been canvassed in detail before you. For certain claims which were purporting to represent the estates of deceased persons without English grants, the judge declined to strike out. This is the carve-out that the court discussed on the first day. The claimants argued that for these claims, the purported representative also suffered damage in their own personal right. It wasn't damage suffered by the deceased. And so in the consequentials judgment, the judge allowed the claimants to amend these nullities to cover loss and damage suffered by the named representative personally and in respect of the deceased's damage. Sorry, suffered by the named representative personally and not in respect of the deceased's damage. And we say the judge erred by giving the claimants this carve-out because it allows a nullity to be amended, not least for it allows a nullity to be amended contrary, we say, to the authorities, but also to the judge's own analysis in her main judgment. And just to show you the nature of what is being done, could I ask you to look at the judge's orders in September? It's in the core bundle, tab 17. This is the order made by the main judge following the consequentials hearing. And page 285, please. And one sees at the top of the page 285, paragraphs 1 to 3 of her order. And paragraph 1 deals with claims originally brought in the names of deceased persons, and she orders that these claims brought in the names of persons who were deceased when the claims were issued or when the claim was added are struck out. Paragraph 2, claims brought by individuals on behalf of the estates of persons who were deceased when the claims were issued or when the relevant claim was added, including the claims which were in the form instructions pending, are also struck out. And the claims purportedly brought by heirs in their own names, but in respect of losses suffered by deceased persons, are also struck out. Paragraph 3. Our concern is with paragraphs 5 and 6, and this is the target of our appeal. Because the judge ordered that paragraphs 1 to 3 of this order, paragraph 5 starting, shall not affect any claims brought by individuals in respect of losses which they suffered personally as a result of the conduct set out in the particulars. And that's the general paragraph that describes the nature of the alleged cartel. And paragraph 6, paragraphs 2 and 3 of this order shall not affect any claims which have been brought by individuals who claim to be entitled to sue pursuant to purported donation of assets in the life of a deceased person. We don't need to deal in detail with the donation of assets point because, as far as I understand, nobody's on that list as things currently stand. So it's immaterial. We still ask for the court to set it aside in case people are added. But as things currently stand, that no claimant claims to have a donation of assets given in the life of a deceased person. If paragraphs 1 and 3 of this order were removed, we would have no objection. There's no objection to individuals being allowed to bring claims in respect to losses which they've suffered personally. Our objection is that these personal loss claims are being allowed to piggyback on claims which are nullities, claims brought in by deceased people or without grants of representation.
Leaving aside paragraph 1 for the moment, if you look at paragraph 2, why is it a piggyback? Isn't it a form of words which covers lots of things, and some of them are not allowed because they're grants of administration and some of them would be all right because they were personal losses. And although it's a cumbersome form of words they've used, it's intended to cover two states of affairs, one of which is perfectly fine and one of which is not fine. And if you have to use piggyback, why is the personal losses piggybacking on the other ones rather than the other way around? You just try to get rid of those things that are offensive in law, don't you?
First of all, there's obviously an important difference in principle between striking out the claims which are nullities and then allowing claims brought by individuals in respect of their personal loss to be made. And that no one questions the right of individuals who suffered loss personally to bring claims.
Yeah.
It is a piggybacking question because if an individual has suffered loss personally, they are entitled to sue us. The reason why the piggybacking is important is because they're concerned about limitation. And so the question for the court is, are they allowed piggyback on these claims which are nullities because they've been brought as nullities? Again, we come back to the question of how does one read the claims as pleaded? How much indulgence does one allow the claims? And it's important to recall the way in which the claims are set out in the claim form. And I shan't bring the court back to them unless you want to. You should remember very clearly. Perhaps I will bring it back to you. A lot of ground covered. The claim form, the bit of the claim form we looked at before was page 33, behind tab 22 in the court. Page 331, for example.
Can you give us a name of somebody who'd be caught by this?
138, the estate of Sergio Stamato, represented by Elizabeth Stamato. I'll see if there's a problem with that example. Let's see, paragraph 72 of our skeleton. Let's see. We gave particular examples. I'm not sure this makes any difference, but if you go to in the claim form, page 353, Viegas Claim 106. Sorry, the numbers are far higher than that. Let me just see. Yes, it's 1006. It's the bottom fifth of the page. Marilena Gresby.
Yes.
I'm sorry, I think I'm looking at the wrong. This is the wrong document. Sorry.
It's the one in your skeleton 988.
Yes. So I'm just going to.
Maybe it is.
Yes, my lord. Yes, that's the one. 988. Maria Menesio Sangali, represented by Bendito Hamudon Sangali. Yes, indeed. Thank you, my lord. So just taking that as an example. That falls to be struck out. But the judge said that to the extent that Mr. Sangali has suffered personal loss, not loss suffered by the deceased, but it is personal loss, then he can amend that and piggyback on that claim.
Or if we forget the words amendment and piggybacking, why didn't we have an order saying that is struck out insofar as it covers all save personal loss suffered by Mr. Sangali. Because it's being benevolent, I understand, but you're treating the form of work as covering a range of affairs which includes personal loss and other loss. But you just say, I think, no, read the words were clearly intended to be a representative claim. And if he wants to read it as something else and it doesn't read like that, that's his own fault. And we shouldn't be creative to try and save that which he hasn't himself saved. That's your basic point.
Yes, and I make it by reference to two key principles. First of all, the reason why you take a strict approach is because this is a nullity. This is not a procedural defect that the court can cure in the interest of the overriding objective. We know you can't use Rule 3.1 to cure these kinds of nullities. And secondly, there is authority on this very point. The Finnegan and cementation case is very similar. And to this extent, it's still good law. And may I just recall, because the fact that the claims are nullities is important. It is important to resist one's natural temptation to try and be indulgent or fix things. We're not concerned with procedural defects. The authority in Kamathi upheld in Jogi could not be clearer. A claim brought in the name of a deceased person is a nullity. A claim brought in respect of loss and damage allegedly suffered by a deceased person without an English grant is also a nullity. And this nullity cannot be cured by amendment, save for the open question about whether Rule 17.44 can be used. And my Lord Justice Newey in Jennison upheld those important points of principle. And we saw that in paragraph 60 of the judgment in Jennison. These are really important points of principle, and it's questions of substance in relation to property rights, not a procedure which the court is more willing to cure. The claimants say that we've just misdescribed the claimant's capacity. And this is an error, it's unfortunate, infelicitous language, we can fix it. But as my Lord anticipates, that's just not credible. These claims were brought, again, as I've said many times, by expertly advised, well-funded litigants. They chose to sue in this form that rendered it a nullity, which the court should not cure, and the judge was right not to cure. It's not credible to say it's a misdescription when it was drafted in such clear terms by expertly advised, well-funded litigants. And what the argument boils down to really is a suggestion, well, although it's described as the estate of Maria Sangali represented by Mr. Sangali, you should really treat this as including a claim by Mr. Sangali. Because in his family's businesses, he might have suffered loss himself. There's no evidence to that effect, but you know how it is. Help us out here. And that argument was made in a much more meritorious case, if I may say so, Finnegan and cementation. May I show you that? It's in the authority bundle behind type 15. Page 520. I should say, and again, the court can place as much weight on the point I'm going to make as you choose to, because I have no evidence to support it. It will be our case in due course if this goes to trial. But the claimants here are not poor, impoverished farmers. The orange producers who are bringing these claims are, to a large extent, very large commercial operators in their own right. And these claims are very substantial. This is not analogous to claims brought by villagers devastated by pollution or flooding. That is not accepted at all. This is a commercial case. But I have no evidence to support that. You'll have to take that from me for what it's worth. But this Finnegan cementation case is of a different kind. Mr. Finnegan from Ireland died in Northern Ireland. His widow, on a building site, his widow got letters of administration in Ireland, which of course were of no use to her in England. As a result, she had no claim in England. It was a nullity, and she was out of time to bring an action in her own right. She was entitled to bring an action in her own right, but she failed to do so in time. You see this at page 520, just below the second hole punch. The action was commenced within the 12-month limitation period, but she brought it as the administratrix of the estate of her husband, but she didn't have English letters of registration. She only had the ones she obtained in Ireland, and now she was out of time. Go to page back, please, to page 514. Submission was made. This is the second paragraph. On behalf of Mrs. Finnegan, counsel said that, skipping down about 5 lines from the start of the second paragraph, the action was brought by the plaintiff both as widow and as the administrator of the estate. She was entitled to sue in her personal capacity as a widow, and that in fact she did so. That her action, insofar as it was based on the Fatal Accidents Act, was good. And we see how the statement of claim was drafted over the page 515. At the first hole punch, paragraph 1 of the statement of claim is that the plaintiff is the widow and administratrix of Patrick Joseph Finnegan, and she brings the action for the benefit of the dependents of the deceased under the Fatal Accidents Act and for the benefit of the deceased's estate. So she actually described herself as the widow and administrator, and she had subject to grants of representation, a representative claim, and a personal claim in her own right. Go please to 522, page 522, and the judgment of Lord Justice Jenkins. Second main paragraph. The second question is whether on the true construction of the writ, read in conjunction with the statement of claim, this was in truth an action brought by the plaintiff in the supposed representative capacity of administratrix of her husband's estate. To my mind, there can only be one answer to that question. The endorsement on the writ says in terms that the plaintiff's claim is as administratrix of the estate of Patrick Joseph Finnegan, deceased. I think it follows that without going any further, we are bound on the authorities to hold that this writ was void ab initio. If I'm wrong in so thinking, it's legitimate to qualify the effect of the writ, which was delivered at the same time. The result must be, to my mind, adverse to the plaintiff. Taking the endorsement on the writ and the statement of claim together, it seems to be reasonably plain that what the plaintiff was purporting to do was to sue in the representative capacity of her husband's estate and in no other capacity. And on that point, on the point of how one reads the statement in this context, Finnegan and cementation has not been overruled. The separate question about whether the capacity can be changed, that is the question under Rule 17.44, which is open, and I've already given you my very short submission on that. But if the court will not intervene to help Mrs. Finnegan, they should not intervene to help the claimants in this case with their greater resources and much stronger team. And the point, my lord, is that the instinct which moves you to try and address the problem was also felt by the court in Finnegan.
They say that all 3 of them, yes.
But they had a separate. It wasn't the how do you read the statement of claim that was upsetting them. The blot on the law was whether there was no way in which she
The limitation period.
Indeed, that's a very different point. On this point about whether you should give a generous and broad textured reading in of words into a claim form, that temptation should be with respect resisted, because the points of principle are important ones, and there is no reason for an exceptional indulgence of that kind here. The remaining point is the claimant's argument that they're entitled to rely on 17.44. And I repeat what I said earlier about the fact that no application under 17.44 has been made or could be made in view of the claimant's case on limitation. This isn't a defect which is capable of being cured it's an issue of substance, and to the extent that they needed an opportunity to address it, that they had that opportunity. One moment. So, my lord, before I sit down, just two short things. The court wanted a definition of heirs. How does one define heirs under Brazilian law? I think my lord Justice Newey asked me this. It's Article 1829 of the Brazilian Code, Authorities Bundle, tab 8, page 27.
Sorry, I'm just going to make sure I get a tag on it. 8, page 27.
Article 1829 of the Brazilian Civil Code. And what they receive, that is the lawful succession order.
So just pausing there briefly so I get a picture of how it works. So this is as regards the bit of your estate that you can dispose of, is it? That you can't dispose of?
This is the succession which is required.
And when it says in the following order, it means that if there is at least one person in category 1, you don't go to category 2, presumably.
I am not able to confirm that, my lord. I have to check because, my lord, that's how I would read this also, but I don't have any Brazilian law evidence on that. All I have is that the lawful succession is granted in this order. That the point wasn't an issue below.
Yes.
There's no expert evidence on it. And what they receive is Article 1846 of the Brazilian Civil Code, and that's Authorities Bundle, tab 8, page 28, which is the next page. And this maybe answers Molo's question. Half of the assets of inheritance belong to legally required heirs. So to the extent that Brazilian law requires you to leave your estate to legally required heirs, they get half.
Yes, I see. Yeah, thank you very
So
much.
it's a combination of the mandatory disposition plus testamentary will. And we have transcript bundles, my lord, also for you. Give them to you at the end of the day. Perhaps that might be the easiest thing to do.
Yes,
Right,
please.
transcript bundles. Once again, if you have any further assistance, those are my submissions on ground 3 of the defendant's appeal also. I finished a little bit early.
Thank you very much. Mr. Shoejoy.
Thank you. I'll try to be as brief as I can. Taking the points in the order in which they were argued, starting with ground 1, 3 points on ground 1. First, the suggestion that the formulation of an amendment as a substitution rather than a removal combined with an addition, that was, as it were, formulated in that way so that we could benefit from relation back. There is obviously nothing in that point, because an amendment either by way of substitution or by way of removal combined with an addition would both bring into play the question of relation back, obviously subject to what the court decides in relation to the first appeal. The second point is that it's not correct in any event that the case before the judge was argued solely as a substitution case. Our arguments to the judge made the point, the obvious point, that a substitution at the end of the day is composed of 2 separate elements, namely the removal of the non-existent null claim combined with the addition of an entirely living claimant's claim. And that was paragraph 49 of our skeleton before the judge. For your reference, supplemental bundle, tab 28, page 472. My third point is simply this. I don't need to go over the meat of the material again, but I made the very specific point that Mr. Justice Stewart in Kimothy had not suggested that if a different capacity, if a personal representative was added as claimant in that case, that would not have been possible by reason of the first strand of the nullity principle. The point that he made was that that would then fall foul of the second strand of the nullity principle, namely that the grant had not been obtained prior to the commencement of the action. And that point I relied upon as indicating that his lordship did not appear to be of the mind that that the first strand of the nullity principle, which is what is engaged by Grant 1, would have prevented that kind of amendment. And my learned friend has not suggested an alternative interpretation of Mr. Justice Stewart's decision in that respect. Grounds 2 and 3. There is no doubt in my submission that there could be a procedural question further down the road in relation to whether, in a case where the heirs who are claimants are neither a sole heir nor the totality of the heirs in respect of a relevant deceased person, that whether pursuant to the overriding objective or by application of English procedural law as a lex fori pursuant to CPR 19.3, directions ought to be made by the court or indeed applied for by the defendants in order to ensure that all heirs of a relevant deceased person, if and insofar as not already parties, should be joined. I readily concede that that is a procedural inquiry that might be appropriate further down the road. But none of this, in my respectful submission, bears upon the question of the substantive validity of the existing claimant heirs titled to sue. So far as the emphasis on the situs of the shows as an action is concerned, 2 points I ask the court to bear in mind. The first is, in a normal case, suing on a cause of action that is yours would not, whether as a matter of language or indeed as a matter of law, be described as collecting the assets of an estate or as part of the administration of an estate. Suing on a cause of action that is yours is simply vindicating a right that you claim to possess. Full stop. The second point I make is that my learned friend's reliance on Dicey Rule 156 at page 1627 of the Authorities Bible, which refers to the importance of the location of movable property in England. That rule is concerned with location of movables at the time of the deceased's death. That is the extent of the rule. There's no suggestion in this case that at the relevant time of death, the shows as an action consisting of the claims under Brazilian antitrust law should be seen as located in England. And so for that reason, we respectfully suggest that rule has very limited relevance in this case, but it has even less relevance by reason of the point that we've already made in our opening submissions, which is that the question of characterization is the anterior question before you get to the selection of the appropriate conflict rule. My learned friend's reliance on Dicey Rule 156 presupposes that he's past the characterization stage, but the rule itself doesn't really assist the court in grappling with the characterization debate. The third point, or the next point I make, is in relation to, if I may say so, the interesting observation that Lord Justice Nugee made about the Chetty and Chetty approach, and why it is, as a matter of principle, if English law would readily look to the lex domicilii as being the provider, if I can put it that way, or the source of a valid title to sue in the case of an executor appointed under a will overseas, even though it may be subject to proof by an English grant in due course. If that is the case, why should the position in relation to a universal succession that occurs by operation of law abroad not similarly be treated by English law in a similar way? And in my respectful submission, that's obviously a powerful point. And if I may suggest a spectrum or a potential distinction between, on the one hand, the pure administrator cases, where the law has been resolute in its refusal to treat a foreign court's clothing of a personal representative with authority as being of any relevance from an English law perspective or from the English court's perspective, that the general conflicts principle being that an English court will not without more automatically enforce the orders of a foreign court, on the one hand, and on the other hand, I would respectfully suggest the line of authority such as Chetty and Chetty, where the devolution of title to sue flowing from the transfer of title or ownership is more readily treated by English law as being something that it is appropriate to look to the foreign law for an answer. And I do suggest that, and I entirely accept that that point is not directly dealing with characterization. It's a side entrance, if you will. And you might almost say that, in a sense, it's eschewing the characterization stage and it's going directly to the question of, well, which is the more appropriate conflict rule? But of course, as you will recall from Macmillan and Rafeisen, the three stages need to be applied or can be applied in parallel in any event. So if you were, forgive me.
I'm not actually sure necessarily that would be the analysis. I mean, it may be that you go through that process, you find that English law is the applicable law, but then you say, well, English law allows a claim by an executor, even though the will is foreign, and then in effect you would say on this thesis, well, really an heir is in the same position. So,
yes.
so it's not actually a question of characterization. It's once you've done the characterization, you've found you apply English law, and then you say, well, actually, this sort of person is really the same as an executor.
Absolutely. So which is the point I was trying to make, namely that I entirely accept that this theory, although in one sense it might be said, well, it's very convenient for you, Mr. Chuchoy, to jump on that particular train. I recognize that, and it might be said to be somewhat opportunistic. But just as points taken against me might be taken by my opponent, I think it's perfectly fair to look at it on its merits. And the simple point I make is this: that whilst I accept it's not a conventional characterization approach, what is interesting about it is that the rule in Chetty and Chetty itself, as I understand it, does not proceed by way of a very meticulous characterization approach. It simply, effectively, identifies what it considers to be an appropriate conflict rule for that particular situation. And of course, what it is seeking to do by choosing that approach is trying to find the law that in the circumstances should fairly be considered to be the most appropriate system of law to apply to the relevant issue. And so what I'm saying, therefore, is if you bear in mind the warning in Macmillan and more particularly Rafeisen, that the three stages can be somewhat circular, or at any rate that they blend into each other, with the overall aim being to try to find the system of law that is most appropriate for the relevant situation. If you adopt that approach, rather than a very meticulous as it were, sequential approach of the kind that we've adopted so far, if you adopt an unsequential approach and a more purpose-driven approach, I would respectfully suggest, from that perspective, there is very much to be said for a rule that in a case where English law would not be seeking to give effect to a foreign court's decision, but simply seeking to reflect the reality of what has happened in the relevant jurisdiction as regards dealing with the devolution of title, recognizing that reality, whether it be through transfer of title to an executor by the will of the testator, or by operation of law. You might even say, in the context where universal succession operates by operation of law in that jurisdiction, one might say, in a manner which is analogous to the executor under a will situation, if you take testators in that jurisdiction to know what the law is, not to have provided otherwise by will, could be said to be a choice for their estate, for their inheritance to be regulated by the general provisions of the law, which is very close, in my respectful submission, to a deliberate choice by instrument to confer title to a named executor under a will. So I do say that is a strand of reasoning which is certainly worth bearing in mind. Much of the debate has and if I may add in that regard, you might say that Vauquelin, in its approach to what, as a matter of reality, legal reality, has happened in the testator's own domicile, is a reflection of that same principle. I mean, Vauquelin itself doesn't enter into a huge debate about characterization, although it clearly, by implication at least, is saying that the relevant issue is not one of administration, but one of succession. But you could liken that approach, in my respectful submission, to the Chetty and Chetty approach. One of the points made was that in relation to the Haji and Ionu case, that the facts were very different. And just to be clear, we're relying on Haji for not for the similarity of its facts to the facts of the present case, but obviously for merely its adoption of the principle that one can deduce from Vauquelin. And going back to Vauquelin itself, as it were, the elephant in the room, if I may say so, in relation to Vauquelin, in the light of all the attempts that are made, understandably, on behalf of the defendants, to distinguish that factual scenario from our case, is this. Let's suppose in Vauquelin, pursuant to the law of universal succession in France, it wasn't just the widow, but the widow and her son, the surviving son, sole surviving son, who would have become the universal donees of the totality of the testator's estate. And of course, we don't obviously know, we don't have evidence of French law, but simply as a matter of analysis and common sense, could it sensibly be suggested that the result, and leaving aside any procedural question that might have arisen as to whether all of the heirs need to be before the court, pursuant to the equivalent of CPR 19.3, leaving that aside, in terms of validity of title, is it reasonable to suppose that the outcome of that case would have been different if instead of a single widow, there had been a widow and some other relative or member of the family who had become joint universal donees of the relevant rights? And in my respectful submission, it's very difficult to see why that should make a difference. Of course, the language in which the evidence in that case was expressed was the widow was absolutely entitled. But as we also know from the case, when it came to the crunch, the court's actual reasoning was focused not on the the fact, as happened in that case, that there was a single person who was absolutely entitled. What was determinative was that the right she was asserting was a right that she was asserting in her personal capacity, in her personal name and right, rather than in a representative capacity. And so we say that's a very important point. Moreover, that reasoning was not in any way obiter, in case Mr. Kennelly persuades you otherwise, because as we know, it was ratio because the widow had two claims, one of which was effectively a sort of subrogation type claim based on her post-death payment, but the second of which was a claim on the bills themselves, which the deceased had, rather than based on the widow's post-death conduct.
Do you understand the two counts to be in relation to the same bills?
They were, as I understand the two counts to be in relation to the same bills,
But they're different claims.
but there are two distinct claims as a matter of law.
There are two ways of getting at the same amount of money.
Exactly, yes. There was then I think another point that's come up from time to time is, well, the idea that, well, if heirs can claim in their own right without the filter, as it were, of the English grant process, well, anybody can come along and claim to be an heir. Well, of course, in litigation, anybody can come along and claim all kinds of things. That's not usually a reason for the court to try to look for some pre-court filtering process. The court, obviously, if allegations are made, they have to be established in due course by means of evidence.
Can I just talk around that for one moment?
Yes.
So suppose somebody claiming to be an heir within category 2, say, of the categories we were showing a moment ago in the Brazilian legislation.
Yes.
Can't remember who's in that category, but assume you're in category 2. So somebody brings a claim on that basis. The defendant knows no better, doesn't object, judgment is entered, and the defendant pays. Then someone else comes along and says, no, I'm within category 1.
Yes.
Someone in category 2 never had a claim.
Yes.
What happens then?
Well, one would expect a well-informed defendant who is unsure whether the claimant who claims to be an heir, 1, is an heir, and 2, is the only heir, which may be what the implication depends, obviously, what the claimants say. But both of those aspects are aspects that are capable of being raised in the litigation, and if appropriate, if, for example, the allegations are all documented and established to a standard that satisfies the defendant, then that should be the end of it. But if it isn't, then obviously the issues in the case can involve potentially whether or not Mr. X is in fact an heir, and even if he is, whether he is necessarily the only relevant heir.
So the burden is thrown on the defendant here to investigate the position in Brazil, and if he gets it wrong, then he's paid out all the money to someone who's disappeared off to Brazil with it, and he has no defence, presumably, to a claim by the right heir.
Well, I mean, obviously there may be mechanisms there may be ways of ensuring that there isn't double jeopardy in due course. I mean, as I've pointed out, CPR 19.3 in a way anticipates that kind of problem in cases of joint owners.
But the defendant doesn't know there's a joint owner. He's presented with a claim by somebody saying, I'm the sole heir under Brazilian law.
But that would also be the case in a CPR 19.3 situation, where a claimant may claim to be the only owner of the relevant asset or cause of action, but in fact, it may be possible that it's a situation of joint ownership, in which case, obviously, that would then be an issue that the defendants would have to investigate carefully, and maybe the subject of maybe one of the issues in the case. But it's very what I understand some of the practical difficulties that may arise, but in my respectful submission, the question of principle of characterization and the appropriate conflicts rule ought not as it were, to depend upon any perceived difficulties, which of course, factual difficulties of this kind, which of course can vary greatly from case to case. So you may say, for example, that in a case where there are 1,500 claimants, this raises an issue of a certain magnitude, which perhaps would not exist in a more run-of-the-mill case. But equally, one might say, well, if 1,500 claimants had all to apply for grants of representation, where each application costs £1,500 plus VAT, plus Portuguese lawyers' fees in terms of tracking down documents and so on and so forth, plus lawyers' time in England, it adds to a rather larger bill. So there's a limit to how far one can push the practical consequences aspect.
I'll just try it a little bit further. So suppose a Brazilian brings a claim here saying, I'm an heir, I am the only heir within a particular category. It's a claim for £20,000. And it's a claim for, I don't know, breach of contract. Is the defendant to be expected to investigate the Brazilian law, the Brazilian family?
Well, one possibility.
Whether there's a will or not.
Well, indeed. I mean, indeed, perhaps Chetty and Chetty might apply in some cases, for all I know. I mean,
Except you'd never get, the will would never cover all of it, it would only cover half of it.
Yeah.
yes. Well, I see that. But the one again, it's not a point I suppose that one's necessarily thought through very carefully. But I quite understand why the court should think about those possibilities. But one possibility, for example, in a case such as this, would be the court saying that although the question of validity of title to sue is not problematical, when it comes to enforcement of judgment or entry of judgment, there is a necessity to protect the defendant by an appropriate form of judgment. And it could be, for example, that when it comes to the later stages of the case where judgment is entered, that a relevant heir in respect of, or perhaps one or more relevant heirs in respect of relevant deceased person might be required to apply for a grant. But that would be, at that stage, that would be rather like in the Chetty and Chetty-like situation, not by way of by way of creation, as it were, of a title to sue that does not otherwise exist, but simply by way of protection, not so much as proof, as in the Chetty and Chetty situation, but by way of protection for the defendant against any risk of double jeopardy.
Can I pursue that a moment longer? As I'm only just thinking this through, but so you're quite right. Where you have a foreign will naming an executor, then under Jennison, the person named has title from the start, but to get judgment, they've got to get a document from the English court. Now we suppose an heir comes to this country bringing a claim. What piece of paper could he get?
Well, I mean, for example, if I can't quite recall now the first order of priority of the heirs, but if it's I think the yeah, I mean, there are obviously, I mean, some of the probate data that we have already disclosed in quite a large.
But do you mean he would get a grant of probate?
No, I mean in terms of underlying documents to show the relation.
But to get the analogy with Jennison and Jennison type cases,
yes,
to achieve certainty, presumably you have to have some mechanism by which the foreign claimant can get something to prove his title here. So what is it?
Well, it doesn't. The short answer is it doesn't have to be a grant of probate. It could be a birth certificate, it could be a marriage certificate, it could be any form of public instrument in Brazil that formally confirms the relation between the alleged heir and the deceased person.
But you'd have to have an expert opinion saying that under Brazilian law, the first port of call is the spouse and the descendants. And then you'd have your birth certificate or your marriage certificate.
I quite accept that there may be some issues of Brazilian law that are raised.
And it wouldn't work the same way. Once you're named as an executor, you bring your claim, you get a piece of paper from the English court which says you are the only person who can claim. Now, that's never going to be true of an heir.
Well, no.
I mean, getting
if you're
supposing a comparable piece of paper existed, it wouldn't say no, that's the only person who can claim, because there would potentially be lots of other heirs who could claim.
Yes, well, in my respectful submission, that is the consequence of a regime of joint ownership, where each of the joint owners of the inheritance has standing to sue under Brazilian law. Of course, in practice, I mean, one can grossly exaggerate the likely difficulties that are going to be created thereby. One would normally expect that if one of the heirs has taken action, the other heirs may be content that particular active heir should take it forward, as long as, for example, they're kept informed, and would not be very difficult if they are members of the same family or somehow related. But of course, I agree. I cannot rule out the possibility that there may be some cases where there is some kind of disagreement which might increase the amount of litigation that might result. I accept that, and likewise, even in the context of grants of probate, there could presumably be disputes between competing applicants within one or more of the three categories that exist under Rule 31B as to who should be the grantee. That's also possible. And that's presumably is possible not least because one of the categories of people who can apply for a grant is an heir, or someone at least who claims to be beneficially entitled. Now, but I quite understand that it might be thought to be practical and convenient, as it were, to shift that debate to those in the probate registry who deal with probate with grant applications. I understand that point, but in my respectful submission, to allow that entirely to drive the substance of the decision would really be the tail wagging the dog. Yeah. Neither the number of claimants in this case, nor the number of heirs, nor any other peculiarities that relate to group actions, which in one respect in one sense might be said to cut both ways in terms of practicality of either their position or my position, should really be allowed to weigh unduly, in my respectful submission, in the analytical process. Not least because there is established case law in my respectful submission, if I'm correct in my interpretation, that draws a distinction between those issues that are properly identified as issues that go to representation of the estate, as opposed to those issues that go to, well, as a matter of substantive law, who now owns the relevant asset or cause of action. That, I think, then brings me to the two, well, effectively the main theme that my learned friend puts forward, in particular in the context of his ground 3, where he says it's very clear under Brazilian law that distribution does not occur until the sharing through the issue of the formal de partilha. Which he says is effectively succession. Now, we disagree with that in the context of ground 3, because, and again, this is where we need to be clear as to the universe in which we're in under each of the grounds. In ground 2, we're in the universe of, ground 2, we're in the world of characterization. How do we characterize the problem in front of us? When you get to ground 3, you are past you've crossed into the other world, which is not that of characterization, but where you've already characterized and you have concluded that the issue before the court is indeed one of succession, and the application of Dicey Rule 164 points to the application of Brazilian law, and you then have to identify what Brazilian law says about succession. And once you understand that, the first point to note is that Brazilian law in terms says that succession begins once there is death. This is clearly stated in Article 1784 and paragraph 14 of Professor Schenck's report. I won't take you to it again, we've looked at it, but Article 1784 marks the beginning of the succession process under Brazilian law. It's no good, therefore, for my learned friend to say, well, we in England have a different concept of succession, whereby, as I said earlier, the timing of succession only follows what may be an extended process of administration, with the actual distribution of the beneficial entitlements not occurring until much later. It's no use pointing to that, because we're in the world of Brazilian law, and Brazilian law itself tells you when succession begins, and that is upon death, pursuant to Article 1784. And this then leads to the second error in my learned friend's approach, and was also the judge's error, in my respectful submission, in the world of Brazilian law, which is that Brazilian law draws a distinction between ownership, collective ownership if there are more than one heir, ownership of the assets of the deceased as and how they stand essentially upon death, which would include, as it were, the unrealized, unenforced causes of action and other causes of action that the deceased might have had, the ownership of which undoubtedly under Article 1784 with the trio, with the other related articles 1791 and 1314 in relation to the regime of co-ownership that is superimposed immediately upon death, that regime applies to the assets as they stand, and those assets include the causes of action. That is why, irrespective of whether there are inventory proceedings open, whether they've closed, whether there's an inventariante appointed or not, as the case may be, that is why heirs or a single co-heir has the legal right to sue, has title to sue in his or her own name. Why? Because succession, i.e. the transfer of ownership, has begun immediately upon death. But Brazilian law recognizes that the individualization of the so-called ideal share in the undivided whole, the ideal share, as I understand it, as a more long-winded translation of the Portuguese version, would be the expected percentage division of the undivided whole. That, I'm not quite sure how a single, I'm assuming there's a single, or perhaps there's more than a single Portuguese expression that conveys that meaning, but I understand that would be the fair meaning of it. But I appreciate there's no particular translation of that. But what mustn't be confused in my respectful submission is the distribution of the individualized interests after assets have been realized, which does come at the formal de particular issue stage, and the proceeding stage, which is a succession stage and began immediately upon death with the immediate transfer of all of the assets, including any causes of action. And what we're concerned with at the moment is not the distribution of the proceeds, although I accept, as we were discussing a moment earlier, there would be any rational court dealing with a situation such as this would want to make sure that there is protection for the defendant in case of a successful judgment, and indeed in case of payment on that judgment. And as I say, there are means of doing that. But in terms of what is immediately at issue, and the subject of the strikeout is the title, the validity of the title of the heirs to sue in their own names. That is what is an issue in the case. It is not how ultimately the proceeds of a judgment should be dealt with. And so in my respectful submission, although these two things are connected, they are different in nature. And Brazilian law recognizes that they are different, because whilst it's, on the one hand, it treats ownership or co-ownership as immediately coming into effect over the entirety of the inheritance and immediately upon death, it recognizes that that is not the same thing as being able to say that this particular part of it, let alone when it's been realized, is this or that as a personal asset. But the point is, under Brazilian law, it doesn't have to be an heir's personal asset in order for the heir to be entitled, pending distribution, to assert the rights that the deceased himself or herself would have been able to assert by way of pursuit of the relevant causes of action.
Now, I've stayed you up a lot, but I expect we've got that point.
I'm grateful. So, my lord, perhaps I can very quickly deal, therefore, with the ground 3 point, because I think I've covered the rest.
Yeah.
And just to make clear, the fact, therefore, that an heir may ultimately, as part of the individualization process, get nothing or get very little is nothing to the point. That does not throw light on the nature of the heir's ownership status in the preceding stage once death has occurred. Ground 3. So, my lord, as you know, there was an important and correct concession by the defendants at paragraph 74 of their skeleton argument that they could not object to the claims of claimants to the claims of heirs, essentially, that were being brought, both as heirs as well as in respect of personal losses. They don't challenge that. That's paragraph 74 of their skeleton. And that's important because even though heirs lack representative capacity as a result of an absence of a grant of representation, they recognize nevertheless, they accept nevertheless, so as therefore to make those claims nullities, they recognize nevertheless that heirs can bring claims in respect of personal losses. They accept that. And the reason, so you need to ask yourself, well, why do they accept that, even though, so far as the claims in respect of the losses of deceased persons, those claims are nullities? And the answer has to be, as a matter of logic, although they've not articulated it, is because a claim in respect of a personal loss is a distinct claim, or you might say a new claim or different claim, from a claim in respect of the losses of deceased persons. But despite that concession, they say, nevertheless, if an heir has brought a claim expressly as a representative of a deceased person, then that heir is in a different position from the heir who simply sued in his or her own name. That's where the difference is, because they say, when it comes to that kind of claim, well, you need to make an amendment by deleting the words of representation, so that then the heir appears as an individual claimant like other individual claimants. And they say that amendment is not possible because of the nullity rule. And our answer to that is, as it is in the case of deceased persons, which is that when words of representation are deleted, essentially what you're left with is the addition of a claim by the relevant named claimant in his or her own capacity in respect of his or her own losses. And that has nothing to do with the claim or in respect of losses of deceased persons. Personal loss claims are simply not affected by the nullity principle because they're claims by living claimants in respect of their own alleged losses. And so there is no issue of non-existence of the claimant by reason of death, nor indeed is there any issue of lack of capacity as at the date of commencement of the action. In other words, neither of the two strands of the nullity principle that we've seen exists in relation to a claim in respect of personal losses. So for that reason, on this short ground in my respective submission, the reasoning of the learned judge at paragraph 15 of the consequentials judgment was impeccable. And so far as my learned friend's reliance on Finnegan is concerned, that is misconceived for the reasons we've given at paragraphs 56 and 57 of our skeleton. I don't think that I need to take you to that now. If you review carefully what we've said about that case, it is distinguishable on its facts, and that should be the end of that particular point. The final point that's been made against us, which is, although my learned friend did not take it up in his oral submissions, is what's said at paragraphs 84 and 85 of my learned friend's skeleton, namely that, well, there's no amendment application before the court. There was none before the judge. And we say that's obviously not determinative because the ability to amend does not turn on the existence or pre-existence of the filing of an amendment application. Of course, the lateness of an application to amend may in due course go to discretion, but that's obviously a different matter. This court is not dealing with the actual application to amend. This court is only dealing with the question of the capacity to amend, because if there is no such capacity, then that might justify the strikeout. So, my lords, unless you have any other questions for me, these are my submissions.
I don't detect any, so thank you very much, Mr. Chuchoy. Mr. Kennedy.
Two very short points. The first is actually in relation to ground 2. And I'm asking...
Are you entitled to make any submissions on ground 2?
The reason why I say I am is because an entirely new point was taken by my friend, where he jumped on the bandwagon, which is floated by my Lord Justice Nugee, about whether...
Floating bandwagon.
Floating. It's getting quite late. I'm sorry. Making even less sense than usual. But the point, my Lord, is you suggested in discussion that, like in Chetty, the Brazilian heirs could be treated as executors. And my own friend adopted that submission and took the point. That's an entirely new point. It's never been raised below or in submissions or anything. And so I have a right to...
There's no doubt that these people died intestate.
Yeah, well, the claimants...
In respect of this part of their claims, yes.
That's my understanding, yes. Yes, indeed. It's no part of the claimant's case that there was a will.
That raises an interesting point, because I've assumed these were all people who were heirs under the one half under the Brazilian part, and what they would get would be one half of the claim, and it's the gardener, the housekeeper, goodness forbid, the mistress, who's going to get the other half under the will.
Yes.
Isn't that what it's going to be? They can't get more than one half, can they? And
yes, certainly that's what if one applies the literal meaning of the provision, then it'll be divvied up. At least that's the starting point, and the rest, who knows where it goes. But the point that I'm trying to address is whether my learned friend's right that this court should treat the Brazilian heirs as executors and adopt the approach in Chetty. And my short answer is that is the wrong approach for two reasons. First, as I tried to say earlier, executors are a special case in England. This is a characterization question, and from the English and Welsh perspective, executors are a special case. Title to sue is granted under a will to respect testamentary freedoms. And so one cannot simply conflate the approach taken to executors with the approach taken when no will exists. And my Lord Justice Nugee's judgment in Genesis made crystal clear in the case without a will, a grant of representation is required. And that's crystal clear. But secondly, it would be inappropriate even as a matter of Brazilian law to treat the heirs as executors in the sense understood in Chetty and in Jennison. As I showed you when I took you to the claimant's own skeleton, it is their case. It was the evidence of Professor Schenk, which was accepted, that the heirs are not responsible for the administration of the estate. That is the task of the inventariante. And the claimants made a virtue of that in their skeleton, and I'll just give you the paragraph references, paragraph 62.3 and 62.4. And it is the inventariante, like the executor, who has special duties to the estate. For your note, Article 618, that's in the Authorities Bundle 1, tab 9, page 266. If an analogy is to be drawn with an executor, it's the inventariante, not the heir. And obviously, my friend didn't point you to any provision of Brazilian law to support his submission, and it was not the evidence of the Brazilian experts below that the heirs could be treated as executors, in the sense understood in the Chetty judgment. On ground 3, one short point. Another friend referred to it as this is the defendant's ground, as a new claim which is sought to be added, but of course it's their case that the person who claims in respect of personal loss has always been there and has always had their personal loss covered. So I didn't follow what he meant when he said it was a new claim. It boiled down to taking a blue pencil to the text in the claim form, and my short answer to that is what is said in the claim form should be given its natural meaning. It should be construed according to the important points of principle which I've laboured before the court, and the reading which my friend seeks to give it would give it a totally different reading. And that kind of aggressive reading in might be appropriate in some public law contexts with which we're familiar, but not in this context. And those are my only submissions in reply.
Mr. Chuchoy, since Mr. Kennelly, understandably, has reverted to ground 2, possibly ought to give you the very last word on that. I'm hopeful there's nothing you want to add.
I don't think that I need to add anything, but can I add a point of detail in case it matters to your lordship's deliberations, which is this, that I understand that some of the claimants have made wills, but none of the wills that we're aware of actually make any bequests specifically of any causes of action to the relevant legatees. In other words, the regime of intestate succession that we've been dealing with will apply as to the entirety of the relevant inheritances of the deceased persons.
That's helpful, thank you very much. Well, you will be staggered to know that we're not going to give judgment here and now. You will obviously be supplied in the normal way with a draft of the judgment. I'm afraid I don't think there's very much chance of that being before the long vacation. When you are supplied with it, you should obviously bear very much in mind the restrictions on circulation that apply, and you will have well in mind the importance that this court has attached to complying with the confidentiality regime. When you receive the draft, we'd be grateful for corrections to our typing and English, but that should not, of course, be an opportunity to re-argue any point. We'd be grateful if, at that stage too, you would seek to agree an order dealing with consequential matters. If there are points on which you disagree, we'd be grateful for short written submissions, and we'd expect to deal with them in the order that we make. Now, I detect that Mr. Chuchoy has some more materials to hand up, and I think, Mr. Kennelly, you did too, did you? Or am I mistaken?
Transcripts, somebody did.
I just wanted to hand up the Yalton authority containing the quote from Mr. Justice Warren's judgment.
Please.
I feel very guilty as to the number of trees that have gone into producing this particular document, but there it is.
Well, it's better than the case I was due to hear tomorrow, which involved an enormous number of trees and has settled.
I'm very sorry, I just realised, Mr. Lucas has reminded me that I never gave my Lord Justice Lewis the language which I said needs to be read into.
Yes, I did wonder.
May I simply read it for the transcript?
Yes.
So at the end of 17.22 CPR, it will be added, or at the same time as filing an acknowledgement of service under Rule 11 sub 7 sub B. The point there is that if it's Rule 11 sub 7 sub B, it means that the applicant has failed in the jurisdiction application and is filing an acknowledgement of service.
Well, thank you all very much. Thank you to those with speaking roles. Thank you to those who have also contributed to this. And we'll leave it there.
I think